Good morning. Nothing, Your Honor. I'm not well. I need to lay down.
Okay.
I protest these proceedings. I'm being railroaded. I am not prepared to defend myself in this.
I need to lay down, Your Honor. I am not well. The man in the wheelchair said it 11 times. He said he had a tear in his belly. He said he was nauseous, exhausted, and in pain. The judge listened. Then the judge offered him 4 options. Every single option led to the same destination. The trial would proceed, with him or without him. The question that hung in the courtroom was never about his health. You are about to understand what the Sixth Amendment actually requires when a defendant says they cannot continue, and why one Wisconsin judge decided the answer was less than the man in the wheelchair believed.
Well, thank you for letting me finally speak, Your Honor. Again, I reiterate what I first said when I entered here. I am not well today. I need to lay down and rest.
Why is
This is the case of State of Wisconsin versus Kevin Lichwick, case number 24 CF 1881, heard in Waukesha County. The defendant faced felony charges. He chose to represent himself, a decision the court accepted after a full colloquy. A formal inquiry to confirm the waiver of counsel was knowing and voluntary. The prosecutors were Chelsea, Thompson, and Dan Tambasco. Standby counsel was available but not active. The judge presided over day 2 of trial on a morning that began with the defendant still in his cell, undressed, refusing to come to court.
We're here for day 2 of the trial. It's now 9:10 a.m. We were scheduled to begin at 8:30 a.m. We got off to a little bit of a late start. Earlier, the court was advised by my deputies that Mr. Lichwick was still remaining in his cell. He was not dressed, and he was refusing to come to court. I had my deputies check with the jail staff to see whether Mr. Lichwick needed more time, whether he was going to voluntarily come up to court, or what the situation was. So we gave Mr. Lichwick.
Kevin Lichwick had been in custody for 18 months. He described sleeping on a concrete slab with lights on him 24 hours a day. He said guards harassed him on the toilet. He could not shower in peace or sleep in peace. He reported an untreated medical condition, a tear in his belly requiring surgical repair.
I'm sick. For one thing, I have a tear in my belly that needs to be repaired. And I refuse to take responsibility for the delays in the length of these proceedings because I needed medical attention. And you're saying I put it off. I did not. I did not receive the proper consultation. I wasn't even allowed to consult with another doctor before I had the last procedure done that I needed. And I have not received all the surgeries that I need. I again reiterate, I have a tear in my belly that...
Whether his claims were provable is a separate question from whether they were heard, and the record shows he made them repeatedly. The cost of his pretrial detention was not measured in dollars alone. It was measured in sleep lost, in dignity stripped, and in a body that he said was failing him while the system demanded he stand trial. The state's case was ready to proceed. Witnesses were present. The jury had been waiting since 8:30 a.m., and by 9:10 they had already lost 40 minutes. The judge made a record that Lichwick was competent. He had asked good questions the day before, made objections, delivered an opening statement.
You asked good questions yesterday. You raised objections yesterday. You gave an opening statement. You're clearly qualified and competent to...
The court had already heard testimony from the jail administrator and a treating physician about his medical condition. Those rulings were settled.
Your medical condition. We've taken testimony previously from the jail administrator. We've heard evidence from your treating physician. And the court has already made rulings about your condition leading up to the case, the previous delays in the case, and the readiness for trial.
The only question that morning was whether the trial would continue, and the judge made clear it would. The options were these: take 5 minutes to dress and return in civilian clothes, remain in the courtroom in jail orange with a cautionary instruction to the jury, participate by video from a holding cell, or be removed entirely and tried in absentia, meaning in his absence, with no defense attorney stepping in to represent him because he had specifically demanded to represent himself.
The options that I'm going to present to you. Number one, We can give you a little bit more time this morning to compose yourself, to do what you need to do, to get dressed into your suit that you were in yesterday, because I'll make a record that today you are in the jail orange and we produced you in a wheelchair. You've been handcuffed for the safety of everyone because we don't know what condition you're in or what your attitude was going to be.
Most people watching this hearing missed what just happened. The judge told a pro se defendant, a person acting as his own lawyer, that if he was too sick to continue, the trial would go on without him and his standby counsel would not be elevated to full representation. That meant there would simply be no defense in the room. This detail passed without comment, but it will matter because it converted a medical request into a forfeiture of the right to be present at one's own trial. We need to pause and understand the constitutional framework here. The Sixth Amendment to the United States Constitution guarantees that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. The Supreme Court held in Illinois v. Allen that a defendant can lose the right to be present in the courtroom if he is so disruptive that the trial cannot continue. But the court also held that trial in absentia is a last resort, not a first response. A defendant who claims illness is not the same as a defendant who swings at a bailiff. The judge here treated Lichwick's refusal to answer a direct question, "Do you want 5 minutes to get dressed?" as non-responsiveness that justified proceeding without him.
You're going to be here in person, you're going to be in the holding cell, or if you're, right now you're not being disruptive, so I'm not going to force you to go back to your cell and just continue the trial without you here. But if you...
The legal question left hanging is whether non-responsiveness due to claimed physical and mental exhaustion is the same as disruptive conduct under the Allen standard. There was no cross-examination in the traditional sense because the defendant was not questioning a witness. He was the one being questioned by the judge about his own body in front of a jury that was about to be told not to hold his jail clothes against him. The exchange was the cross-examination. The judge asked if he wanted time to prepare. Lichwick said he needed to lay down. The judge asked again. Lichwick said an hour would not help. The judge asked a third time.
You haven't listened to a word I said, Your Honor. With all due respect to the court and the people of Waukesha County, I am not up to being here today. I need to lay down and rest. I am not well. That's all I can say. I've said it before. I've said it twice since I came in here. I've told your deputies and the jail staff at least 4 times on the way up here. And the fact that they were hurting me. So I'm not being heard.
Lichwick said he was not well and could not answer anymore.
To say, I need to lay down, Your Honor. I need to go back to my cell and lay down. That's all I can tell you. When I feel better, I'll let you know. That's all that's the final word here. I don't know what else to do.
Well, that's why I'm offering Mr. Lichwick.
The peak moment came when the judge asked whether the state had a position. The prosecutor said Lichwick was non-responsive and the state was ready to proceed.
No, I think that the options the court laid out are the available options. Mr. Lichwick has not really made a decision. He's non-responsive to the court, so I think we proceed with the trial. The state has witnesses here, and we are prepared to proceed.
A man who said he was sick was deemed non-responsive, and on that characterization, the trial moved forward. Here is what would actually happen in the real world with this ruling. A defendant who is too exhausted or unwell to participate meaningfully in his own defense can be forced to trial anyway, and if he refuses to engage, he can be removed and tried with no one speaking for him. That is not a hypothetical. It is what the judge explicitly threatened. If Lichwick continued to protest, the trial would proceed in absentia with an empty defense table.